Redding versus Ali was interesting because it was accepted by both parties that this would be a test case in how the principles established through a body of case law could be applied to modern technology. The pivotal issue here was whether the Uber model constituted plying for hire. Redding counsel claimed that Mr. Ali, the defendant, was in possession and control of his car, which was not a hackney carriage. He had chosen to travel to and wait in Reading at a time when and in a place where members of the public were likely to want to be immediately transported somewhere in a vehicle. They also argued that he was logged on and shown as available on the Uber app. His location and availability were displayed to users of the app by an icon on a map. Redding counsel contended that this constituted availability and solicitation, and in their view, plying for hire. However, the Chief Magistrate for the case found there to be insufficient evidence for her to conclude that the defendant was illegally plying for hire, and consequently found Mr. Ali not guilty and dismissed the charges. The Chief Magistrate for the case was Lady Emma Arbuthnot, and I'll come on to her in just a moment. Now let's roll back the clock a little when Uber first lost its licence to operate in London. Among the issues TfL singled out in a 21-page explanatory document were Uber's facile approach when it came to reporting assaults, criminal offences, issuing driver background checks, and obtaining medical certificates. TfL also cited the company's lack of corporate responsibility with potential public safety and security implications. All legitimate reasons for revoking their licence, you could say. It was slightly different because TfL chose not to revoke their licence. Instead, they chose not to renew their licence when their current licence had expired. And as expected, Uber appealed the decision, and because the legislation is as it is, Uber was allowed to carry on regardless until their appeal was heard. And the appeal was doubly interesting because TfL chose to adopt a neutral position, leaving the decision to the appointed magistrate. The appointed judge at Westminster Magistrates Court granted Uber's request for a temporary licence. The judge said, taking into account the new governance arrangements, Uber is now fit and proper. The magistrate for the case was, yes, you've guessed it, Lady Emma Arbuthnot. Now you might say, this makes complete sense. She has experience in dealing in cases involving Uber. She also has experience in dealing in licensing. So what was the beef? Well, the beef was Lord James Arbuthnot, Lady Emma Arbuthnot's husband. Roughly around about the same time, the Observer newspaper investigation raised questions into links between her husband, Lord Arbuthnot, and Uber. The article reported that Lord Arbuthnot was a former director and consultant for a company called SC Strategy Limited, and one of the company's clients was the Qatar Investment Authority, widely reported to be a significant financial investor in Uber. On the 18th of August 2018, the Guardian newspaper published an article in respect of District Judge Arbuthnot. The article claimed that the district judge had withdrawn from hearing further appeals regarding Uber, and this is what triggered the challenge by the United Trade Action Group to seek a judicial review of Lady Arbuthnot's decision to grant Uber a licence. In brief, Chiltern Law argued two cases of bias. The first, where the existence of bias is presumed, i.e. whether the outcome of a cause could realistically affect the judge's interest. That made sense. The second category of bias is where there is a possibility of bias on the part of the judge, which requires that the decision should not be allowed to stand. Again, that made complete sense. Chiltern Law also argued that the senior magistrate had acted ultra vires by granting the type of licence that doesn't exist, and in doing so, used illogical and implausible reasoning. In summary, the evidence was as follows. Lady Arbuthnot confirmed that she knew her husband was chairman of UK Thales Advisory Board. She didn't know of any Thales connection to either Uber or TfL. She had no knowledge concerning TfL's selection of BlackRock to manage investment portfolios, or that BlackRock invested in Uber, and she had no idea that her brother used or supported Uber prior to him being asked. The judge also stated that it was abundantly clear that Lady Arbuthnot did not grant a provisional licence without considering whether Uber was, at the time of the hearing, a fit and proper person. So there you have it. Either you agree with the outcome of the verdict or you don't. But it goes some way to demonstrate the extent to which Uber has tentacles absolutely everywhere.